The matter before the court is State of Maine versus Idris, and this is Andrew Scoggin, 24-105. Counsel appear to be present. If counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with appellant.
Good morning, Your Honors. Tim Zerillo for Kai Idris, along with co-counsel Damian Ramsdale.
Good morning, Your Honor. Kate Bozeman for the State of Maine.
Thank you. We are being streamed, I believe, live on the web. And if counsel are ready to proceed, Attorney Zerillo would be happy to hear your argument.
Madam Chief Justice Stanfill, justices of the court, counsel, along with Damian Ramsdale, I represent Kai Idris in this appeal here today. May it please the court. This appeal takes up a nagging issue of the appropriate scienter in the gross sexual assault statute, in this case under 253 sub 2 sub d. There, innocent sexual acts are separated from criminal sexual acts for two reasons. One, because the other person is unconscious or physically incapable of resisting, and two, the other person has not consented to the sexual act. Particularly in the case of mutual and voluntary intoxication, such as we have here, these lines can become blurry. But the court's reasoning below that a reckless scienter should be applied instead of at least a knowing scienter was error. It was also error to instruct the jury only that the scienter applied to the issue of consent and to ignore the other element. The court twice instructed the jury that the mens rea of recklessly applied only to the consent element, saying that the state must prove the complaining witness was unconscious or otherwise physically incapable of resisting the sexual act, and that she had not consented to the sexual act, and that with regard to whether she consented, that the defendant had acted recklessly. That's found on page 478 and 479 of the trial transcript. Human sexual interaction is a very complicated topic, and I am far from going to propose to solve it here. But the overarching argument we are making is that the mens rea must be sufficient enough to make the proof of each element meaningful. This court said it in Assad. This is a complicated and nuanced area of human behavior. Knowledge is what separates innocent conduct from criminal conduct. And on its face, 253 sub 2 sub d requires the state to prove both consent and the resistance element, or unconsciousness. Why both elements were not given the instruction as to scienter here, I do not know, but should trouble this court and as grounds to reverse the decision, particularly in light of Supreme Court precedent that has repeatedly emphasized that scienter should apply to all non-jurisdictional elements of an offense. I'll be happy to take your questions.
We said previously that we were uncomfortable venturing into the area of policy. In other words, what should be the level of culpability for someone who engages in and then fill in the act. And we told the legislature that this was not our prerogative. In Assad, it didn't affect the outcome because we concluded that under the standard that he was arguing for, that it would have satisfied the elements. So here we are today, we're looking at a different section, and again, we're in the same position of being asked to set a level of capability for people who engage in sexual acts with people who are unconscious or unable to physically resist. And I'll say out loud, we're equally uncomfortable with that position again this time around. The legislature, as you know, for subsection M, provided for criminal negligence at that level, the consent issue. The language of consent is the same in subsection D that we're looking at here today. And I'll ask you, I'll have a follow-up question, but I'll ask you, why should we not gravitate to the definition or the level of culpability the legislature set for consent in subsection M here today for subsection D?
Well, first of all, because it's insufficient. The Supreme Court has constantly recognized that.
Can I just, sorry to interrupt you. You say insufficient, could you be specific? Insufficient what they did for subsection M or insufficient specifically for subsection D? What's insufficient?
Well, I think I'm not arguing subsection M today, obviously, but I would argue that it's insufficient.
Well, I wasn't sure if you were making that point, that they missed it on that, even on subsection M.
I am making that point, but obviously it's not the issue here today. I mean, I think that part of the point is overriding between the two subsections, which is that the mens rea is insufficient as a matter of substantive due process. The legislature did not appropriately.
Well, let's talk about due process for a minute, because the foundation of that argument is U.S. versus Morissette. And the foundation is that even though ignorance of the law is no excuse, there's innocent, ordinary people would think it's innocent conduct, and therefore you're not getting adequate notice when you engage in that it should be illegal. So are you taking the position that someone having sex with an incapacitated person is engaged in something that an ordinary person would say is innocent conduct?
Well, I would quibble a little bit with the word of incapacitated, because the issue is whether they're aware that they're physically able to resist. That's, I think, a slight nuance there. And the issue is, I guess, I'm not sure if I'm answering your question, Justice Connors, but the issue for me there would be, given the nuance in human sexual behavior, particularly when drinking is involved, and we know that these assaults spring from drinking behavior constantly, that there must be a sufficient mens rea, and I don't know.
But I'm focusing on the due process argument you've made, not what should be the mens rea for legislative history, but the gravamen of the due process argument is that it is ordinarily considered by ordinary human beings to be innocent conduct. And are you positing that this conduct, as expressed in this language of the statute, the ordinary human being would think it's perfectly innocent conduct?
I think that if the ordinary human being knew, if it's clearer if the person is unconscious, as opposed to the latter clause, which is they know that they're physically incapable of resisting.
But you're saying it's okay for a person to consciously disregard the risk that the other person is unconscious and hasn't consented. That's your position.
Well, I'm not saying it's okay. I'm saying that.
Well, you are, though. You're saying
Yes,
it
you
has
are.
to be more than that.
Yes, it has to be knowing. I'm sorry, Your Honor, I misunderstood your question. Yes, I'm saying it should be knowing, but in this case, it was never even instructed on for that first clause. So there was no mens rea given to the jury whatsoever. It was a strict liability crime as to whether or not, as to the resistance
Well,
element.
there was an instruction given on consent as to recklessness.
Yes, but it was so directly to the issue of consent. And I tried to point out in my opening that the trial court justice twice instructed that the mens rea only applied to the consent element.
What about the reference to attendant circumstances? In other words, the full recklessness instruction in this case focused on the consent element and then made a reference to attendant circumstances. Could the person's conscious or unconscious state be viewed as an attendant circumstance?
Well, I think, if I'm remembering correctly, that's how it was interpreted in Assad, that the mens rea, the attendant circumstances instruction as to the scienter should be applied. But regardless
Well, in
of...
Assad, there really weren't attendant circumstances that we were talking about. It was simply not consent.
It was not consent, and it was very clearly manifested in the facts of the case. And getting back to your question, I think, Your Honor, I think the question as to whether or not the attendant circumstances scienter could be applied to this case is it could. We are just saying it should be the knowingly scienter and that it should apply to both of the elements the state is required to prove.
Counsel, was that specific objection made below? I know there was a lot of discussion about what's the appropriate level of mens rea, but there wasn't any specific exception to the instruction that did not flesh out what an attendant circumstance was. Isn't that right?
Justice Douglas, I think that's fair. It's a little bit convoluted, the record. I think the state said in its brief that it was not clear whether that had been preserved. I think that's a fair characterization, that it's not clear. There was a lot of argument over several days related to the level of the mens rea, knowing versus reckless versus criminally negligent. And then, as we mentioned in our brief, the trial justice said, I want no further pushback and I'm going to instruct. Our argument has been that at that point the justice said there was no further pushback, and that even though it's not clear that trial counsel meant to make an argument that knowing applied to the entire clause, both clauses rather.
So are we reviewing that specific issue on an obvious error standard?
Well, I would still like to try to preserve my argument that it was preserved below, that he was making an argument that knowing should apply to both the resistance and the consent element, but I will acknowledge it is not as clear as it should be on the record.
Can I bring you back to the argument you're making? I mean, given the legislature's response to Assad in subsection M, and saying that, A, we are intentionally, by the way, rejecting the idea that voluntary intoxication ought to be a defense to this, and B, that the appropriate mens rea is a criminally negligent with regard to the lack of consent. Do I understand you to argue, and do you agree, that if we were to go along with what you're saying, we necessarily are also saying that M is unconstitutional? Is that what you are saying?
I think M is unconstitutional, to be just completely frank, but I would say here that this court could weigh in on this subsection without touching M necessarily. And the reason why I say that is it's never been addressed
Well, yes
before.
and no, but if we say that recklessness is insufficient for the consent element in subsection D, never mind the other element, but if we say it's insufficient for the consent element, aren't we necessarily saying it's insufficient under subsection M?
I think it is insufficient, so that wouldn't bother me if you did say that, but I guess the only thing I would say is that we are dealing with a different class of crime. So.
And actually, that takes me back to my original question. We kind of took an off-ramp on that question as you were answering it, but I would like you to answer that, which is legislature set out criminal negligence as being the mens rea for consent in M. D also has a consent condition. Why? I realize you feel it's insufficient, but is there a distinction between M and D that would justify us gravitating to a different mens rea for subsection D?
Well, I guess, other than the class of crime, Justice Meade, I think
Right, it's a higher class of crime.
It's a higher class of crime here than in Assad.
But the higher class of crime is because M is sort of generic lack of consent. This is an unconscious person or a person incapable of defending, so that certainly would raise the classification, but does that really touch the consent definition?
Well, I think arguably then this court could require a higher standard of mens rea as a result of the fact that more is required to prove this case, particularly in the fact that this seems directly on point to issues of intoxication and so on.
Okay.
There don't appear to be additional questions. Thank you.
Thank you.
Attorney Bozeman, so you're here for the DA's office, or aren't you with the AG's office now?
I am recently with the AG's office,
Okay.
but I am here in the capacity as trial counsel for this case.
Okay.
Good morning, Chief Justice Stanfield, justices, may it please the court. Contrary to what Mr. Idris suggests to this court, his trial for gross sexual assault contained none of the error that he claims, and his conviction should be affirmed. Idris suggests that the court erred in instructing the jury on a stricter mens rea than that imposed by the legislature in a similar subsection of gross sexual assault, where none presently existed, and in response to this court's decision in the state of Maine versus Assad. In this case, the trial judge instructed the jury on a recklessness standard, as opposed to criminal negligence that the state had requested. As this court noted in Assad, determining the appropriate mens rea for crimes of sexual assault like the ones at issue here is an important and unsettled area of law, and the standard of behavior should be determined by the people's elected representatives. The people's elected representatives did just that in the similar statutes within 253, as well as the accompanying unlawful sexual contact statute, and determined that criminal negligence was the appropriate culpable state of mind. The state again argues that because of this, criminal negligence is the correct standard for this case and this statute as well, and therefore the trial judge imposing a stricter standard of recklessness was in no way error. Idris's argument that the jury should have instructed on a knowing mens rea so that a voluntary intoxication defense would not be prohibited is completely contradicted by the legislature's actions and was an issue that was specifically addressed when determining what level of culpability was appropriate. To quote from testimony presented to the Committee on Criminal Justice and Public Safety, a knowing mens rea and availability of a voluntary intoxication defense under these circumstances would be a huge step backwards in Maine's efforts to reduce sexual violence and should be rejected. Similarly, Idris's contentions that the medical records were improperly admitted is both unpreserved for appeal and unsupported by the record. These came in without objection at trial based on statute that allows for their admission, as well as a hearsay exception. The statements made to the medical providers that were introduced at trial were all for the purposes of medical treatment and diagnosis and admitted with the explicit acknowledgement from the defense attorney that they were not objectionable. Finally, Idris's challenges to the state's closing argument, all of which were unobjected to at trial, should fail because the entirety of the state's arguments were centered around and oftentimes quoting evidence that was properly admitted at trial. For those reasons and those discussed in its brief, the state respectfully requests that the judgment of conviction be affirmed, and I would be happy to answer any questions that you have.
You correctly pointed out that the people have spoken through the legislature, and they clearly said that for subsection M, criminal negligence satisfies the mens rea requirement. They didn't talk about any of the other offenses in 253. What do we take from that? Can we assume that they meant to cabinet simply to subsection M? They weren't constrained by the case. They were looking at a statute itself. And from that, do we assume that even though they didn't say it, they meant to spread criminal negligence across all the mens rea in 253? Or was the contrary make more sense that no, they're only limited it to subsection M and left the rest of it down the road, perhaps for the law court to help them out?
I guess I can't speak to whether or not that was purposefully disregarded. I do think that I would echo some of the court's suggestions earlier that the specific clause at issue within 253(2)D and 253(2)M, the language is identical, and therefore I think the legislature's changing of that, or determining that criminal negligence was appropriate in that regard, as well as in the accompanying unlawful sexual contact statute, should speak to this court in terms of what is the appropriate determination in regards to the statute at issue here.
In Assad, the suggestion was actually that we needed to have a mens rea was actually not based on a due process analysis. It was actually just simply based on the plain language, which is the plain language of consent, in that case, not expressly or impliedly requires that there be no express or implied acquiescence, and that same analysis has to apply here, doesn't it?
That there needs to be a mens rea element.
Yes, in other words, it was not based actually on a due process analysis. It was simply based on the language of consent.
And I think the state agrees with that and agreed with that at trial, that there did need, given the ruling in Assad, that there did need to be a mens rea read to the jury in regards to that element of consent.
But what about the other element about unconscious or otherwise physically incapable of resisting?
I would answer that in two parts, Your Honor. At the outset, I don't believe that that is preserved for appeal. So I believe it was Justice Douglas that asked this earlier. I do think that the court needs to be reviewing that on an obvious error standard. Additionally, the state does not agree that that mens rea needs to flow to both elements of that statute. And specifically, the important takeaway I would suggest from Assad, and the reason that the court came to determine that a mens rea needed to be read, was that that element of consent or implied acquiescence sort of signals a two-way street, that there needs to be a communication and an understanding. And there is nothing about the plain language of the first part of this statute that would make that similar suggestion or that would require...
So you're saying that first part really is simply an objective determination?
And in attendant circumstance, I think I would suggest that it is a question of fact for the jury.
But an attendant circumstance is an element of the offense, isn't it? And doesn't the code pretty clearly say that there must be a mens rea component for every element of the crime?
I think, Your Honor, what the state's point is to sort of liken that to a circumstance like a person's age, that that is a question of fact for the jury to determine, but that portion of the statute in itself does not need a culpable state of mind in the same way that an element, that the portion regarding consent would.
It's a pretty important fact. It separates subsection D from subsection M, doesn't it?
It does separate those. It is a fact that changes the section of the crime. Yes, I would agree with that. But I do not agree that the mens rea needs to flow to both of those, because I do believe that the state's suggestion is that the plain language of that statute, there is nothing about those words at the beginning of the statute that would require a culpable state of mind in the same way and under the same logic that the consent element does, flowing from the Assad case.
So in other words, from your perspective, if I understand you to say so, even if the defendant had no reason to know that the person was incapable of resisting, if in fact the person was incapable of resisting, the defendant can still be guilty.
I don't think that that's what the state's suggesting. I think,
Well, otherwise they have to know, right? Or at least negligence, recklessness with regard to that fact.
I think, Your Honor, that the plain language of that statute, that the jury would need to find the person. And I would also distinguish, there are subsections within the gross sexual assault statute that talk about a person being mentally incapacitated, for example. There is, I would suggest, a pretty clear difference between a person being mentally incapable of something and physically incapable of something, or
Well, let's assume that somebody's lying in a bed and they are paralyzed and unable to physically, incapable of resisting. Does the defendant have to know that?
The defendant has to know that the other person is incapable of consenting, which is an important part of this statute.
Well, does it say incapable of consenting in the statute?
Sorry, that the person has not consented, so that element is important.
So you're saying that the first part, unconscious or otherwise physically incapable of resisting, is really sort of an objective determination for the jury to make whether that is in fact the case, and that the second part, lack of consent, has to be both that it in fact was no consent, but also that the defendant was negligent in not understanding that.
Yes, Your Honor, and I also think that that's an important point to bring up in regards to the defendant's due process argument that there is a wealth of innocent behavior that would be criminalized by this conduct. All of the examples that were brought up as some of that innocent criminal behavior would not be so if the consent element was not met. Correct. So a consensual bondage relationship, again, if a person, it is that lack of consent and that recklessness or criminal negligence in regards to whether the other person is consenting that would criminalize that conduct. As with the example of a long-standing agreement between married people that they could engage in sexual acts with the other when they were unconscious, that it is the change in the consent that criminalizes that behavior. So I disagree with the defendant's suggestion that there is this whole host of innocent behavior that would be criminalized if the mens rea didn't flow through the entire statute.
I'm still struggling, though, with the mens rea and the attendant circumstance. You cited age as another example, but in the sexual assault statutes that involve age, those are strict liability offenses. This is not a strict liability offense, and the code pretty clearly says for every element of the crime, and this is an attendant circumstance, it is an element, there must be a mens rea component. Doesn't it?
I think, again, Your Honor, I would echo Justice Stanfield's recitation that the state believes that this is really an objective fact, that portion of the statute is an objective fact for the jury to determine, and there is nothing about the nature of those words that would require a culpable state of mind in the way that the latter
Is that because the defendant has nothing to do with bringing about those circumstances? Is not for purposes of guilt. The defendant is not required to have any involvement in bringing about those circumstances.
Yes, Your Honor.
Well, also, I'm reading the statute that says you have to have it for every element. And it says, when the definition of a crime specifies the state of mind. It doesn't here, does it? So why would this statute apply at all?
It doesn't, and I think that perhaps the suggestion is that it should, and that the decision in Assad's would suggest that part of it needs to. So I don't know that statute applies at all, but I would reiterate that the state does not believe that it applies to both elements.
If we were going to say, well, in the abstract, when there is no mens rea included by the legislature, what are the steps that we use? We look at context, we look at, you've argued, we look at what they did with M. And isn't one of the other things we look at, what was the common law? You know, so what should be the default when they say nothing? And isn't traditionally this a crime of general intent, which would mean it could be anything from, it could be recklessness? And isn't that why the model penal code has the default recklessness, looking at the common law? So at the
I think
highest,
that's called a softball question.
so wouldn't the highest that you would get under the common law be a recklessness mens rea?
I think I would agree with that, Your Honor, and also, and I would again also point out that looking to the legislative history of these similar statutes, that the highest that there should be, should ever be, would be recklessness as well, because this issue of voluntary intoxication was specifically fleshed out. And I also just want to bring back to the state's point that the state suggests that even under a knowing standard, the evidence in this case was well sufficient for the jury to have found the defendant guilty.
Even if the evidence is sufficient under a knowing standard, if in fact the jury was only instructed as to recklessness, can we substitute our judgment for the jury's?
I agree that that is a differentiation between this case and the Assad case, but I also think it's important to address, at least from the state's perspective, we have a very different view of what the defense now argues is the facts that the jury heard, and that is that these really were diametrically opposed testimonies from the defendant and from the victim in this case. And the victim's testimony was supported by a wealth of other things, but ultimately the jury would have had to entirely disregard the defendant's testimony, and if that were the case, the victim's testimony was extremely clear. I would disagree with the suggestion that that there was evidence that she was blacked out drunk or that she was forgetting parts of her night. I think that is sort of parsing out sections of the testimony that when looking at the whole...
Well, and that may be supportive of some of the physically incapable.
And actually, doesn't the standard of recklessness fold in a certain knowing element? And recklessness involves a conscious disregard of a known risk. So in order for the jury to have found Mr. Idris guilty, they would have had to have concluded that he consciously disregarded a fact that he knew, which was that she was functionally unconscious at the time.
Yes, and I again would suggest that the victim's testimony also would have made that an extremely clear, if believed, question for the jury, because her testimony was...
She said stop.
Well, and that she had been asleep for hours and woke up to the defendant vaginally penetrating her and then immediately told him to stop, and he did not do so. So really the jury, in coming to the conclusion that they came to, would have had to entirely disregard the defendant, and if believing the victim, it was quite clear from her testimony that she was unconscious.
But they would also have to have concluded that he consciously disregarded a risk.
Yes.
In other words, she might be unconscious, not knowing what she's doing, but I'm not going to think about that. So there is folded in a knowing element. I'll be asking your opponent that same question in just a moment. So he has a little prep time there, but thank you.
Thank you.
Mr. Zerillo, can I just ask one quick question about the medical testimony? Isn't the testimony that you cited as being erroneously admitted just simply cumulative or duplicative of what's already in the records, which were admitted without objection?
The record issue is a little unclear to me as well. The trial counsel, Your Honor, said that he would admit the record subject to redaction. I don't know what redaction.
Okay, but my question is, do you agree that the testimony that you're complaining about is really duplicative or virtually the same? In fact, they were reading from the record in some cases.
They were reading, yes. I would agree they were reading from the record. The only reason I'm hedging it all there, Chief Justice, is just because I don't know what was redacted.
Okay, thank you.
In Assad, we said that even if it was a knowing mens rea, he's still guilty under that standard. Can we do a similar thing here and say that because the reckless instruction was given, and that does imply conscious disregard of a known risk, that we get to the same point?
Leaving aside the physical resistance element,
Yes.
I still don't think you get there, because Assad is so much clearer on its facts that this couple was engaging and about to engage in some sexual contact. It was very clear that only if condoms were used, that was allowed by one of the parties, and condoms were not used, and it was very clear.
This is much less clear. But the jury found him guilty. They found beyond a reasonable doubt that he consciously disregarded a known risk.
Only as it related to her consent, not as it relates to the other elements. So we can't credit the jury in that way. It's not like we can sit there and say we just must assume.
Well,
that
they
the
didn't
jury's made a
find,
decision.
maybe, they may or may not have found that he consciously disregarded the risk that she was unconscious or otherwise physically incapable of resisting, but they found that, in fact, that was the case, or they could not have convicted him.
Well, I don't know that that's even taken up, though. Based on the way I read the instructions, it doesn't seem to me that that's something that's posited to the jury based on Justice Stewart's instruction.
Okay, thank you.
Thank you, Your Honors.
Thank you, counsel, for the argument in this case. As is our usual practice, we will be taking the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.